Now call the third case on the morning docket, 117301, in the matter of the parentage of MF, a minor child, brought by KL versus TF Appaloo.
May I proceed?
Yes.
Thank you. May it please the court, my name is Valerie Moore, and I represent Kim, the non-biological mother and appellant in this action. I would ask to reserve 3 minutes for rebuttal.
3 minutes is reserved.
Thank you. Kim and Tara were in a same-sex committed relationship for 7 years. At the time, marriage was not legal in Kansas. During their relationship, Tara became pregnant through artificial reproductive technologies, and their daughter was born in 2013. In 2014, the parties separated, and Tara slowly reduced Kim's access to their daughter, so that in 2015, Kim filed an action under the Kansas Parentage Act. This case involves a fundamental question about what is required under the Kansas Parentage Act as it pertains to same-sex couples. And I think this case needs to be viewed in conjunction with Obergefell, because prior to Obergefell, same-sex marriage was not legal in Kansas. And because of that, parties were extremely limited in what they could do. And they could not enter into a legal contract of marriage and know that that would be recognized in Kansas. Kansas specifically passed constitutional amendments and statutes saying that same-sex marriage not only is illegal in Kansas, but would not be recognized if somebody was married in another state. So therefore, parties were inherently unequal. That was modified with Obergefell. And going forward, parties do have the ability to get married, but there's no requirement that they get married. Marriage is always a choice that people can opt into. The Kansas Parentage Action helps deal with those situations where people did not get married. And it sets out the statutory framework for establishing parentage. With respect to a mother, 232207 applies, and it says that a mother may be determined by giving birth to a child. Although I think it's important to note that you can give birth to a child that's not biologically your child, whether it be a donor egg, a surrogate, whatever. It does not mean that you are necessarily biologically related to a child just by giving birth to that child. And again, the statute says may prove. It doesn't say is proven, but may be proven. With respect to the other parent, the statute that we look at is 232208, which lists the presumptive ways that a person can be declared a parent. Marriage or attempted marriage, notoriously or in writing, including but not limited to, the signing of a voluntary acknowledgement of paternity form, a VAT form, biology, genetic testing, or a support order by the court. As the court previously noted in Frazier, only one of those deals with biology. The rest of them have to deal with various ways that families are formed. The idea of marriage was that children were unfortunately chattel and the property of the husband, and so we wanted to make sure that children born during a marriage were related to the father legally. The genetic testing really only came about in the 80s and 90s when we had the technology to do the genetic testing. The support order, as the court knows, you often can declare somebody to be a legal parent without them having any of those connections. If they default, they fail to show up, whatever, the court can say you are dad without any finding of a relationship between the child and that parent. Where we are here today is the part of the statute that talks about notoriously or in writing. What's important about that is it says notoriously or in writing. It doesn't say notoriously, comma, in writing. It doesn't say notoriously and in writing. It says notoriously or in writing. So that means that the court can determine that someone is a parent based on their notorious actions or based on a writing.
What are we to make of the fact that the statute frames all of these options in terms of presumptions?
I think that is a good question, because that is the issue. Everyone is a presumption, is a presumed parent.
If it's a presumption, then it's asking the question, what evidence is sufficient for us to recognize something that already exists? In other words, the person's already a parent. The question is just, what evidence is sufficient for us to acknowledge that? Isn't that what a presumption is?
Correct.
So it seems to me that we oftentimes turn this on its head, or we utilize these evidentiary factors to establish and then declare a legal relationship, as opposed to simply recognize one that pre-exists the presumption.
And I think that's just the nature of, again, going back to the olden days where we knew a child was the mother's because she gave birth, but we never quite knew who the father was. We can assume it was so-and-so based on the party's actions, but we did not know. And so...
But correct me if I'm wrong, but as I understand your argument, you're asking, and you have support in this because I think this is what Fraser did, you're asking us to utilize those presumptions as ways of creating a parent-child relationship.
Correct.
That didn't exist prior to those evidentiary actions.
Which didn't exist legally.
And so there's at least some tension with that interpretation and the idea of these as presumptions. Isn't there?
I would say so. Okay. And I think that that's fundamentally the problem. Because when you have a presumption of parentage, there is no legal finding that you are a parent. Whether you sign the voluntary acknowledgement of parentage form, whether you are married, whether you're genetically related to the child, there is not a legal presumption of parentage. You have to come to court. You have to file something to say, I want to be legally recognized as this person's, as the parent of this child. And so we are kind of adding this extra step that people have to do to be declared a legal parent. Now, obviously, in the cases of marriage, it's a little bit simpler because generally people are not arguing. But we often have competing presumptions. And that's why we have the statute that just lists all the ways that you may be a parent. And then if there's a competing presumption, then we can kind of deal with that. But if there's not a competing presumption and you meet the statutory factors, you are a parent. That's what the statute says. It says you are a parent if you meet these factors and there's no competing presumption. And so if you establish your prima facie case that you are a parent under the statute and it's not rebutted, you are a parent. And I think that if they had wanted it to be an order of preference, they could have said this is an order of preference. Number 1, number 2, number 3. But they list all of these ways that you can be determined to be a parent. And they're not an order of preference.
Where did the trial court go wrong here in making the determination that it did? Didn't it really weigh all of the factors that you're asking us to say that the court should have weighed and made a determination? Went to great lengths to do that, it appears to me.
I think the issue is the standard that the court used. Because the court used a discussion of open and notorious assumption of parental responsibilities. That's not what the statute says. The statute says notorious acknowledgement of parentage. It does not say you had to act in the role of a parent to be considered a parent. And I think that's important because, again, if we're taking gender out of this situation and you just have a man who, had one night stand and is biologically related to the child and didn't do one thing to assist with the helping of this child, we would not say he's not a parent based on that.
But this person is not similarly situated to someone who does have a biological link.
I think under the statute they are. The statute doesn't say a biological link is more important.
No, but aren't you getting the cart before the horse? They aren't a biological parent. They aren't an adoptive parent. So they do have to demonstrate that one of these applies. You can't use the fact that they have to demonstrate that to mean that they have demonstrated it. Isn't that kind of circular?
I think that the evidence is that they notoriously recognize parentage of the child.
Okay, so let's just stop you there for a second because that brings up another question. How does this work? Or I guess I'll ask it this way. This is in tension, is it not, with the biological parents' constitutional right to raise a child and determine parentage of that child?
I think if we're talking about parental preference, my client is a parent. She has the parental preference. If she meets the statute and shows that she is a parent, then she has parental preference. It is not a gift that one party gets to have. If you meet the statute to say that you are a parent, then you have that parental preference. And so she has the parental preference the same as biological mother.
Okay, so go ahead.
Go ahead. Follow up.
Well, I was going to return to Eric's question, so you go ahead.
Okay. So if by, for example, signing a voluntary VAP form, I could impose upon someone else a relationship of parenting, even though that other person is a biological parent that might not want me to have any right to parenting. I can just take a situation and by signing a form, become a parent.
Well, the VAP form can only be signed by male. It cannot be signed by a same-sex parent. And as part of that, the birth mother also signs the form as well, acknowledging. So both parties are signing
And
this
because
form.
of that, it probably wasn't the best example, but my point is just, doesn't it have to be some type of an agreement? The biological, in some situations where there is not biology, that for a parent to have to share parentage with someone, or is it a one-way street? Can that other party just declare, no, I am going to parent and I have legal rights because of that?
If they meet a prima facie case for showing that they notoriously or in writing recognize parentage of this child, I think yes. Because they have met the statutory factors to show that they are a parent. And so because of that, yes, they are a parent. And so the other parent has waived his or her rights, if you will, with respect to parental preference by allowing this party.
That's the piece I'm struggling with. Let's just back it up. Let's try to back it up. Is the biological mother's waiver legally necessary?
For what? To
In
establish
order-
parentage?
In order for this presumption to apply to the non-biological mother? Or is this presumption applicable regardless of the intentions or desires of the biological parent?
I think as part of the discussion of the notoriously or in writing recognized parentage, that comes into play. How does it not? Because to recognize a child, I don't just walk up on the street and decide that this person's my
I
child.
want to make sure we're not talking past each other. I'm trying to distinguish between the activities or behaviors or writings or acknowledgments of the biological parent versus the non-biological presumptive parent or potentially presumptive parent. This presumption speaks to the behavior of the non-biological, right? It doesn't talk about whatever's going on here with the biological parent.
Correct.
So my question is very, very basic. Does it matter? Does the behavior or acknowledgement or consent or agreement of the biological parent matter at all to the applicability of the presumption in favor of the biological parent's status?
I would say it does not, but it is evidence, if that makes sense. So it is evidence of, it goes towards some of the evidence that would be used to show the notoriously, but it's not a fundamental requirement that the biological parents waive this interest or fundamentally say, I'm allowing you to be a parent.
And I think waiver is kind of a misnomer anyway, because they're not saying I won't be a parent. They're just saying I'll share.
Correct. Correct.
But
And
you're
that's what you
saying
said.
that desire to share is unnecessary because the plain language of the statute only requires that the non-biological parent make it evident through behavior or words that this child is his or her own.
Yes, that's what I would argue, because the statute says that. I mean, the statute, again, it's not an order of preference.
What are
It's
the
a-
limits on that? I mean, you earlier said, well, we're not talking about somebody who just walks up on the street and says, I'm your parent. But what are the limits?
Well, if there's competing presumptions, if there is somebody else who is in that role as a parent for that child, you cannot just notoriously assume that role, because then...
I thought that's what you just argued to Justice Breyer that could happen. That because I thought I understood you to say that the biological mother's consent or waiver is unnecessary.
It is, but if there's two parents who are presuming to be the second parent to the child, so if we have competing
So is it limited
presumptions-
by number then? You're saying that parentage is limited to two. Is that what I understood you just argue?
I mean, I'm not gonna weigh in on that, because I think that they...
Well, I'm just trying to understand the limits of your interpretation of the statute.
If there are competing presumptions, so if mom is married to somebody, and even if that person is, let's say overseas or something and has not stood in the role of parentage, but they have a presumption of parentage. And then you have this other person that maybe has notoriously recognized parentage of this child. So then you have these two competing people recognizing parentage of this
For
child
the second parent.
as the second parent. Yes.
So do the competing presumptions, in your view of the law, only come into play when there are more than two parties?
Well, that's what the statute says. It says if two or more presumptions apply, then we look to the weightier considerations of policy and logic.
And the birth mother doesn't have to have a presumption to be a mother under the KPA, basically.
It says may prove by giving birth. It says may prove, but as I said, she may not be biologically related to the
We
child.
appreciate that, but that's not our case today. We'll walk down that other windy road another day. But basically the biological mother is not subject to the presumption statute, period. She's got another way of being a mother under the
She
KPA.
is a presumed parent as well.
Yes.
So
but not-
I'm
but
saying
not
they're all
under
equal.
this statute. Well, you are and you aren't. That's the problem. Is there, my colleague's question is there any limit? And maybe the answer is just no. The statute's written the way that it is, and that's it.
I don't think there are limits if you can prove you notoriously acknowledge parentage of the child.
So for example, if the biological mother had a series of relationships, 6 months each, and each of the women she was living with during those periods notoriously recognized the child, each of them would have a presumption, and then we'd go into a trial to determine which is weightiest.
Yes.
Or is there actually a two-person limit?
I don't think there's a two-person limit because the statute says if two or more presumptions apply. I just did a trial where there was 3 presumptions. It happens.
But at the trial, you limit it to 2, ultimately.
So
I
they
think-
can't all win, in other words.
I would say that's probably fair.
What about the circumstance in which one of the parents has passed away, so there's only one living parent, and another person simply claims notorious and open parentage?
So
Is there anything, does that just make that person the parent then?
are you talking about?
Because there's no other person to come in with a competing presumption.
And are you saying that the biological parent died, or just the person who notoriously?
No, I'm saying there are 2 parents. One is deceased, so now there's only one parent, and a third party makes this open, notorious acknowledgement. Does that just sort of slide that person into the slot of parentage, regardless? Because again, your argument is that it does, unless there's a competing presumption.
Well, if parentage has been established, then no, the person could not just come in and be a parent. So if parentage had been established in some means, I don't know, what those means would be, if the name's on the birth certificate or whatever, and there was these 2 presumptions. No, I don't think an unrelated third party could just come in and become parent to this child. I don't think
I'm having a hard time understanding why not, under your legal framework.
Because again, it's that notoriously. So if you had somebody who previously was in that role, we don't just get to have somebody else come in and take over that role.
But they're gone. They're out of the picture. They can't assert any competing presumption.
And the remaining parent doesn't have a say, right? Is that the other piece
Yes,
of it?
right.
Again, I think that goes to the trial court deciding, is this notoriously a recognition of parentage? And is that notorious recognition of parentage, if we have this competing presumption, which is in the child's best interest? Because at that point, there would be a competing presumption. Now, that person may not be able to testify or be there because they're deceased, but there is a competing presumption.
Let me go back to where I was with my first question, is that you're talking about the non-biological parent meeting a statutory provision, or the statute to show parentage. How does that happen? And how did the district court not do that here? But first, it's an evidentiary hearing, isn't it?
It is.
And what does the non-biological, for lack of a better term, have to show? What is open and notorious? What satisfies that?
Well, Black's dictionary is going to define it as generally known, widely known by people. That's generally what's going to be said. This court in old decisions from the 50s talked about how referring to a child as my baby.
The trial court, in some ways correctly, in some ways in my mind was troubling that they got into the behavior of the party seeking parentage and tried to equate it with what is responsible parental kind of duties, satisfying those duties. Does it go that far, or is there something less than that?
I think it's less than that.
And what is it? That's what I'm trying to hone in. Where do you draw the line?
And I think that is fundamentally the issue with not being able to sign the voluntary acknowledgement of parentage form. You couldn't do a second parent adoption. Marriage was not legal, so you're limiting parties' ability to be able to show this. Now, I think going forward, it's going to be a little bit easier. But for now, this was an issue. So what is notorious? I think it is letting others know that, hey, this is my child. When speaking to providers and daycare providers and the school and whomever, that this is my child. That is an acknowledgement of parentage.
Counsel? Excuse me.
No, go ahead. That's fine.
Are you finished?
Yeah.
Okay. Counsel, I think the original question from Justice Rosen was, what did the district judge do wrong here? Even if we accept your view of how these cases should be approached, what evidence matters, what did the district judge do wrong? And I was just going to ask, is there any kind of problem that arises because there's no explicit burden shifting that's happening? Do you agree that the burden originally rests with your client, who has to make a prima facie case under a preponderance standard, shifts to the respondent, who then must rebut the presumption with clear and convincing evidence, and then ultimately, if that is successful, shifts back to your client to
Correct.
go forward with evidence? So that rubric applies. Did that happen in the district court?
Not in this court, because the district court ruled that she didn't meet her prima facie case of parentage. So there was no burden shifting. They didn't get into the other parts.
Okay. So there was a recognition that would be the standard, and in your view, your reading of the record is there was a recognition that the burden shifting applied here, but she just didn't make it past the first hurdle.
Correct.
Okay, thank you.
That's what I would say. I think the district court found that there was not an open and notorious assumption of parental responsibilities, parenting responsibilities. That was the standard they used. And I think that that's, again, an unfair standard. When you are not legally married and don't have a court order forcing somebody to co-parent with you or to act as a co-parent with you, you are left with no other option than to go to court and present your case and get declared a parent. So you are somewhat working out of a hole from the get-go if you're not being treated as a co-parent by your other parent. It is no different than when we're dealing with a dad who mom won't let him see the kid, and so he has to file an action. And he proves he's parent, and then we move forward with the parenting time.
Do we have an equal protection claim in this case, though?
I do believe there is one. I think
But it hasn't been formally listed as an issue, has it, up to this point in this case?
in this case, no. The one after it is brought up, but in this
I
case,
just want to
no.
be clear, we really don't have that preserved in this case.
Yes, Your Honor, that's correct.
Was the judge using that standard as the legal test, or was the judge using that standard as a method for weighing the credibility of the statements that there had been an open and notorious statement of parentage?
Well, I think when the Court of Appeals looked at the issue, they said it does appear that she showed notorious parentage of this child. But then the Court of Appeals kind of goes towards the writing part and the fact that there's not a writing between them. So I do think there's substantial evidence to show that she notoriously recognized parentage of this child.
But substantial evidence does not necessarily, if there's substantial evidence on both sides, we don't reweigh what the district court's conclusion would have been.
Unless they use the wrong standard. And
That's
so
why I'm asking, did they really use the wrong legal standard, or did the judge here use that really as a method of saying, yes, now there are some declarations of a desire and willingness to be the parent, but that at the, casting doubt really on the chain of events that are used. So.
I think it is the open and notorious assumption of responsibilities. That's not what necessarily meaning being a parent has anything to do with, and is not listed in the statute. The statute is just marriage, biology, signing a voluntary acknowledgement of parentage form, or notoriously or in writing. It doesn't say that you acted in the role of a parent.
I have one more hypothetical question because I'm
Okay.
trying to just discern the contours of the argument. Let's say that a child is a few years old, and at that point, a party notoriously acknowledges parentage, and can be recognized as a parent, is your argument at that point, correct?
Yes.
If that were to happen, was that person a parent before they notoriously acknowledged parentage? Or did the parent-child relationship only come into existence at the notorious acknowledgement?
I think at the time of the notorious acknowledgement is when you became the parent. Because I think it's analogous to you can get married and then sign the birth certificate. And so you are a parent essentially from the time that you got married and signed this birth certificate and became the parent. The same as when we do the genetic testing. We can, obviously we're retroactively declaring that you're a parent and can make you responsible for child support and those kind of things. But I think it's from when the notorious part started.
Thank you.
Excuse me. Were you in essence asking a relation back question? Is that pretty much what you meant? I didn't understand. Would it be retroactive to the child's birth? Was that the
No,
question?
I really just wanted to know whether or not the person was a parent prior to the open acknowledgement.
Okay, thank you. And you basically said no.
Correct.
Okay, thank you.
Okay. Thank you.
If it please the court, Christopher Vendeska appearing on behalf of TF, Tara. Also joined as counsel for Tara by Alex Flores. TF does not appear today. Your Honors, we appreciate the opportunity to appear before you and basically, from our perspective, seek some finality, seek some conclusion to this case. That basically began in the court system in 2015. It wasn't filed until a calendar year after the biological mother left the shared residence. So
That was the point at which there was going to be a move to another state, right?
just to clarify, and that may or may not match the time frame. The child was born in October of 2013. Mm-hmm. In November of 2014, the biological mother and the child left. Mm-hmm. The biological mother got engaged and advised the non-biological party in May of 2015 that she was engaged to be married. She actually married and moved, I believe, in October of 2015, and then the action was filed in November of 2015.
Okay, thank you.
And so, but during the period of time after the move out occurred, there were just sporadic contacts. There wasn't a regular parenting time schedule. There was contact acknowledged, admittedly. And Judge, your Honors, just to digress, basically to be clear, what we're asking the court to do is, our position is that there's no basis to overturn the district court's decision. There's not a basis to reverse or alter the Court of Appeals decision affirming the district court. I think the court, from our perspective, did a very detailed factual analysis. And what that was necessary for was because it's rooted back to the assertion of this notorious assumption of parenting or basically the operation of the presumption. And there were many competing facts that both sides presented. Ultimately, the court weighed the evidence, and to the extent that that those issues are being disputed now, the court at this level is not able or is not supposed to reweigh the evidence. There
I
was.
think Judge Smith went even beyond that too. He talked about credibility, competing credibility as well. But this is my question arising out of his observation that where the evidence was disputed, he tended to credit one party over another, that being the biological mom over the non-biological party. Wasn't it essentially undisputed that the biological mom attempted to foster the non-biological party's parenthood?
I would say that it wasn't disputed that there was a relationship encouraged, but I would say other than the few steps taken that were ultimately established prior to the child's birth or contemporaneous with that, that was not something that was ongoing as far as there wasn't evidence that there were significant steps, basically during the periods of time that they cohabitated or they lived together after the child's birth.
That was about a year, right?
That was about a year. So during that period of time, until the child was about 1 year old, I don't believe that there was evidence during that period of time that there were significant steps taken by the biological mother to encourage, I guess, to push or to put the non-biological parent in a maternal role.
My recollection is that she said very specifically in her testimony that stopped in the September right before she left.
Your Honor, I would have to refer back to the record,
Okay,
but
you rely on the record for what it says.
Certainly.
And what the district judge ultimately found about
Sure.
what she did post-birth.
Sure. I
Okay.
think the abundance of the evidence was that from the point in time that the child was born, there was not a sharing of parental responsibilities. There was not a sharing of financial responsibilities. Basically, all of those parenting responsibilities, the caregiving, ended up being the direct responsibility of the biological parent. All of the financial responsibilities. And there was evidence presented. There was some testimony, but not a lot of these points. There was evidence, well, of course, on the points that the court ultimately reached a conclusion on. Most of these points, there wasn't, sorry.
Let me
Your
see
Honor.
if I can try to help you tease out what's interesting to me.
Okay.
What I'm struggling with. It seems to me that we have at least 3 different things in play here. Evidence that has to do with whether someone is a parent under the presumption or whatever law you say applies. And then evidence about whether someone's a good or a bad parent. And then evidence about whether someone is a good or a bad partner in the relationship between the adults. And I'm having some trouble with the record in this case because I think those things got kind of jumbled up.
Sure.
So maybe you can explain to me which pieces of evidence in particular you're relying on to demonstrate that this presumption did not apply.
Thank you, Your Honor. Well, I think our argument isn't that a presumption didn't apply, is that it wasn't satisfied. I think that
I
was the
understand
court's
that.
determination. So,
Okay.
basically,
So obviously there was testimony from one party that it should apply because she acknowledged. And the position of your opposing counsel is that acknowledgement is all that's required. That you don't need these additional performance or assumption of duties. And I'm suggesting that they may fall into the category of whether you're a good or a bad parent, but maybe not whether you're a parent at all.
sure,
See what I'm saying?
I understand.
So what was the evidence in your view that disputed the facts as testified to by the non-biological parent?
Sure.
Did the biological mom say, I did not consent, I never consented, I never agreed, I never attempted to foster a parental relationship with my partner?
Sure, Your Honor.
Okay.
I'll do my
That
best
helps
to.
me,
I'll do
that
my
helps
best
me
to.
stick to the question we're really here about.
I
Which is
understand.
parentage, not quality of parenting or quality of partnering.
Okay, well, I'm going to address those, what I understood to be evidence ultimately and factual determinations by the court, but then I would like to speak to the legal framework as well. So
course, thank you.
basically, and just to understand, the manner in which this was presented to the district court in end of 2015, beginning of 2016, was counsel's argument began with the Kansas Parentage Act and the presumptions that, of course, that was the basis that was pled in the petition of Kim, notorious or in writing. And shortly before 2015, or within a year or two, we had the benefit of having the Frazier decision, which kind of leaned that out and synthesized and basically made tangible for practitioners, maybe parties, those that sought legal advice. Actually, in this case, the parties were suggested to seek legal advice, but they didn't, prior to the child's birth, what may have put us in a different position depending on what the intents were. But so with that, basically the case was presented, I think, somewhat uniformly by the two counsel, that Frazier sets out the guidelines and the parameters for which the court is supposed to evaluate and interpret the evidence to ultimately determine whether there was a notorious or in writing assumption of parenting or parentage. Sorry. So basically, there was quite a bit of evidence by both parties focused on, because we're operating under this precedent. This precedent was based upon Frazier, a knowing, intelligent writing a parenting agreement. And there were so many details in so many things in the Frazier case that these two parties did to affirm that their intent was to co-parent. Their intent was to share parenting responsibilities. Their intent was that if there was ever a separation, both parties would have contact with the children. They even did estate planning and identified the other ones as guardians in the event of their death. So the court's looking at the district court is looking at what did the Supreme Court rely on to interpret and apply the Frazier facts to be an extension or an interpretation of the Kansas Parentage Act, which certainly doesn't have all of that detail and traditionally does refer to different genders. And so with that...
Sorry, counsel, I need to ask a clarifying question.
Yeah.
It sounds like you're saying that the district court took upon itself the task to determine as an evidentiary matter whether or not an agreement existed.
Yes, in so many words, because kind of cutting to the chase, that was a component.
And then, just to cut to the chase, the follow-up question is, I understand your opposing counsel's argument to be that whether an agreement's required is actually a legal question, and if the district court got that legal question wrong, then its evidentiary findings are essentially they're at least not determinative of the case.
And obviously, we don't agree with that approach. From our perspective, there is some, as far as how the presumptions apply, not to go too far into history, but historically, a presumption was rooted in extrinsic evidence of some type of underlying fact. In this case, it would be biology. Well, historically, it would be biology. The legislature later recognized adoption as a way to establish legal parental rights. So to the extent that our position is and was that to the extent that there's a presumption that operates here, it's still got to be rooted in some type of fact.
Sure, but I'm trying to discern whether or not the district court believed that an agreement had to exist before this presumption could kick in. And it sounded to me like you were saying that is exactly what the district court thought, because the district court looked at Frazier and saw all these facts that were in Frazier related to a detailed agreement.
Yes, it's our understanding that the district court, when it basically went through the analysis, weighed the evidence, actually specifically cited evidence to the extent that here's evidence in this case that's similar to evidence that existed in the Frazier case where the KPA was extended to.
So why, I guess just my last question, why is the district court correct as a matter of law that an agreement's required?
Well, I think from our perspective, to the extent that there is to the extent that there is a root in a presumption, that is something that if it's not going to be based upon a biological connection, or
Why can't it just be based on an open, notorious acknowledgement?
well, it's just a matter of so we don't agree, and I think this is a distinction to be made. We don't agree that somebody, a third party, can notoriously assume parental rights.
Isn't that what Fraser says? That's exactly what Fraser says.
Well, so there's a distinction to be made here, and bear with me. Basically, the interpretation that we made, or the argument that we made, was basically when there's a presumption, there still has to be some type of underlying connection. So historically, that may be the fact of biology, which these presumption criteria may be evidence of. And I understand that's kind of a historical, maybe even antiquated perspective, but for this to apply, there still needs to be, if there's notorious conduct or written conduct, that still has to be written. Still has to be rooted in an agreement. And frankly, in Fraser, it was rooted in an agreement that was written and very detailed and accompanied by significant conduct reflective of the practical agreement.
And again, it sounds like you're asking this court to build upon Fraser and clarify that, yes, an agreement is required.
Judge, I think that, Your Honor, I think for the sake of consistency, that just seems like it's a necessary component. I think the court should conclude, and counsel and parties and district court judges who hear these cases somewhat regularly now need the direction that, and think the clarification. Can a third party unilaterally assume parenting rights, or is there a requirement, if it's not biological, that there be an underlying written agreement? Can that assumption of rights operate, or the presumption operate unilaterally, or does it at least have to be bilateral? Bilateral meaning, yes, it's got to be at least rooted in the consent, the knowing consent, either, well, under Fraser, which is the precedent that we're operating under at this point in time. We've had other cases like Downs versus Gilmore, unpublished, persuasive, not necessarily precedential in the same way that the Fraser case is. That case spoke to that there needed to be this written agreement, and that rooted back to the parental preference doctrine and the body of law in Kansas that said a parent can't give those rights to somebody else unless they're knowingly and intelligently waived and certain conditions are satisfied.
She's not giving up her rights, though. She's sharing, right? I mean, I'm having a little bit of a struggle on what it exactly, if an agreement is required. Let's just assume for purposes of argument that we're going to say it's some sort of agreement between the biological parent and this other potential parent is required. Then what is really happening? What is the biological parent agreeing to do? Isn't the nature of the agreement to share, not to give up, not to waive rights, or at least it'd only be a partial waiver, right?
Well, I think I'm not aware that the distinction was made. So basically, for there to be the requirement of a written agreement, and I believe this is how it was interpreted and applied in the Fraser decision, but the court determined that for those rights to be assumed by somebody without, by a third party, the person who possesses those rights had to affirmatively cede those rights knowingly and intelligently to another person. And so that, in this case, basically, theoretically, the presumption could still operate, and frankly, I believe that was the interpretation. It operated in the Fraser case because the presumption was rooted primarily in this written agreement, also by other conduct. There was other conduct in that case that showed that there was an agreement, parenting agreement. In our case, though, all that the court had to rely upon, and there may not be significantly more now, but it was somewhat limited, was the Fraser decision, which was precedent, and also to some degree the Downs versus Gilmore decision, where the Court of Appeals, and it wasn't challenged at a higher level, but the Court of Appeals determined that the presumption path for third-party parentage could also apply in situations where there was a non-written agreement. But frankly, that case was very fact-specific, and there were so many things that happened in that case that were specific to that case, and maybe that's the reason why that didn't become a published decision. But what the district court had in our case to rely upon, basically, it went through the factors that it found in Frazier. Was there a committed same-sex relationship? Yes. Was there a joint decision to have children? No. Was there a signed, detailed parenting agreement? Whether or not that's what it turns on, the answer was no. Was there a verbal agreement as far as a co-parenting agreement? The court's determination was no. There was no verbal agreement, certainly not evidenced by practice, the practice of when the parties remained living together for a year, and certainly not after that point for the 12 months that passed before there was any legal action taken.
Counsel, in Frazier, the court applied the presumption in KSA 23-2208A4, notoriously or in writing recognizing paternity of a child, right?
Yes, Your Honor.
In those words, where is there some requirement of an agreement?
Your Honor, as codified by the legislature, I believe that language roots back to, I think, 1985, as codified by the Kansas legislature. At the point in time that wording was created, it didn't apply to circumstances. It was ultimately expanded to apply to circumstances where it's the same gender relationship by this court. And even though there's been opportunities, the legislature has not modified or recodified that specifically to apply to situations where it's the same gender circumstance.
When it was passed, did it apply to different gender? Did it apply if the person attempting to establish parentage was male? Did it apply regardless of marriage?
I think that's how it was intended to apply.
In
Certainly.
1985. Yeah. So what difference? I'm afraid you're cutting off your nose to spite your face here on an equal protection claim. I appreciate that's in the other case, but what difference does it make?
Well, it certainly wasn't contemplated by the legislature at the time that the law was passed. The extent to which, as it's been interpreted by the Kansas Supreme Court, to authorize extension of parenting rights in situations where it's the same gender relationship.
Okay, so granted that may not have been in the mind of legislators at that point, but what difference does that make to the question that was asked by Judge Lieben about where in the words is there a requirement of an agreement? What difference does gender make to that?
Well, I think facially reading it doesn't make a difference. But as far as the interpretation that exists in the Frazier Agreement that basically interpreted and applied that statute that doesn't specifically reference same-gender relationships, that was extended under those circumstances based upon there was a presumption, but the presumption operated in conjunction with and was rooted in a written parenting agreement, and certainly rooted in significant, and I can go through all the points that didn't exist in our case that existed in the Frazier case.
Frazier was the Cadillac case.
Right. I'd be reluctant to assign a model to our case.
Counsel, the 1985 statute included also another provision that was relied upon in Frazier, KSA 23-2220, that says any interested party may bring an action to determine the existence or non-existence of a mother and child relationship. Insofar as practicable, the provisions of this act applicable to the father and child relationship apply. So it recognized, even in 1985, that we could have presumptions that could apply to either. And the court in Frazier, before this case was litigated in the district court, decided specifically that subsection A4, notorious or in writing, could apply to a mother, potential mother, just as it could to a potential father. So I'm still struggling with how, from that statute, we get to any requirement of an agreement, let alone a written agreement.
Sure. Well,
I mean, in this case, there was the birth certificate that originally gave the putative mother's name as the middle name for the child, and there was at least some period of time where the two proposed parents were living together with the child.
correct, yes.
Judge Rickey found that one parent didn't really act as much like a parent, but on the other hand, there is something there that would form a basis for notoriously recognizing parentage,
Judge,
if an agreement's not required.
sure, and I respect the opportunity to give feedback because some of this certainly is less than clear. As far as the operation of the presumptions, I mean, the analysis, and there isn't, fortunately, we do have the Frazier case. And for practitioners, from a practical perspective, practitioners commonly have cases on both sides of this component. So in this instance, I represent the biological parent. I've had instances where I represent the other parent. So, but it's in circumstances where the law is less than clear, it can be somewhat challenging. So to the extent that the presumption is based upon or rooted in some type of existing fact, the presumptions set forth in the statute, when codified, refer back to a root in biology. The statute later was modified to the Kansas Parentage Act to also, I believe it frankly was contemporaneous to include the root of adoption. But the root now, to the extent that we're not looking at biology, we're not looking at adoption, but we're looking at, well, is there a path when there's a presumption that's not based upon the existence of a parent-child relationship? And Judge, I can refer to that statute, but there's a statute that specifically says for parent-child relationships, 23-2205, a parent-child relationship means the legal relationship existing between a child and the child's biological or adoptive parents.
Well, you've argued that the presumption, what's being presumed, is the biological root. Was Frazier just wrong to expand that?
I'm not that it's not my position. It's not our client's position that it was wrong. It's certainly there's some distinction to be made.
Well, if it wasn't wrong, it seems to me you're running squarely into the hurdle proposed by Judge Lieben that there is no root. It's just open, notorious acknowledgement.
Well, it's consistent. I mean, that's one could approach that analysis and reach the conclusion that it was wrong. I think in this case, the Supreme Court was justified, or there was a basis for its decision, because instead of being a root, this presumption, instead of it being rooted in biology or in adoption, it was rooted in a written agreement in Frazier. And that written agreement was necessary for the biological parent to cede not all of her, 100% of her rights, but she, at the time, possessed those rights legally. She agreed to share those rights. So that was the root that the presumption related back to in the Frazier case. And I believe the court found that even though there's a parental preference doctrine, that the 14th Amendment to the United States Constitution applies here, protecting a biological parents to care, custody, and control of the child, that was overcome. That had been considered and protected by the fact that there was a written, very detailed agreement that this biological parent, knowingly and intelligently entered into. So in that case, was the presumption operating in a circumstance that didn't root back to the historical biology or to adoption? Yes. Did it still require that there be something bilateral for this presumption to operate? Yes. There had to be a written agreement. A party couldn't claim a presumption, at least not pursuant to Frazier. There's not authority for that in Frazier, that a party can unilaterally claim operation of a presumption without some significant steps, the written agreement in that instance being taken by the biological parent. again, the Gilmore case, the Downs versus Gilmore case, made that a little bit less clear. But in our case, the overwhelming evidence, well, the evidence that the court relied upon, and I would acknowledge it, to some degree there was disputed evidence, but there was no undisputed evidence put forth by the appellant that wasn't countered, and the court ultimately made the determination and made factual determinations that more weight should be given to the evidence presented by the biological parent. I think the court justified that with detailed findings and ultimately determined that the presumption didn't operate because in this case there was no agreement, there was no written agreement, there was no agreement in practice, and so the petition was denied.
Thank you, Counselor. Are there other questions? All right. I appreciate your argument.
Okay, I didn't make it into my own materials too far, but if there are any other questions, I'd certainly be happy to assist you. Thank you.
I think it's fair to say that a writing would be preferred. I'm a family law attorney. Divorces would be a lot easier if everyone had a prenup. We wouldn't have to probate estates if everybody did a will or a trust. But it's unrealistic to think that parties would, one, know this child was only born a mere 8 months after Frazier was decided, so that they would have known that they could have entered into this contract together, especially when, as I stated, the law in Kansas was somewhat flux. We had the Frazier decision, but there was a constitutional amendment saying, that same-sex couples were not going to be treated the same. And until that had equalized, there was no guarantee that the legislature wasn't going to fix this statute. I think that what the district court and the Court of Appeals essentially did was say that Frazier is an exception to the biology requirement. But that's the very thing that Frazier rejected. Frazier specifically said that we were going to look at the statute and all of the statute, and that a woman could make a colorable claim to being a parent. Parentage is a statutory framework. We have a statute. And so if you meet the part of the statute that says that you notoriously or in writing recognize parentage of the child, you are a parent. I would love to tell you that this case is unique. It's not. Attorneys are dealing with this on a daily basis. At this current moment, I have several. There's some in the Court of Appeals. There's 2 here today. This is not a unique situation. It is a situation that's happening all the time.
I think I need you to do something for me that it seems like there's a lot of clutter in the arguments about what may happen in this case or that case. I want to care about this case. So just connect the dots for me. How does KL unilaterally establish the parent-child relationship under the Kansas Parentage Act?
I think you need to look at the context of this case. They were a family. They lived in the same home together. They purchased property together. They paid bills together. They were a family. They didn't have the benefit of marriage, but they were a family. When this child came home to a family of 2 parents. That was what this child came home to. And so this mother assumed that responsibility notoriously or in writing, and so therefore she is a parent under the statute. This is not some stranger off the street. This is where the child came home.
So required in that scenario is at least, if not an agreement, an acquiescence by the biological mother. I'm just using labels here to keep them straight rather than using initials, but that there is at least some acquiescence by the biological mother to these circumstances that you're laying out.
I think I don't want to call it acquiescence because that's basically saying that she is the only one that has this ability to acquiesce. That's not the situation. This child was born to a family. And so both of those parents have that ability and have the rights with respect to the child.
Let's say that you're not committing yourself to the necessity of acquiescence. Would you agree that the evidence may demonstrate acquiescence?
Yes, I think it can demonstrate it.
I mean, all you can do is play within the facts that you have, which is part of my disagreement with making Frazier too big a deal, because Frazier just is its facts.
Yep.
And so so it may be easier because you've got certain facts. That doesn't mean you had to have those facts to get where you want to go. I'm still, so I'm trying to focus on what it is that you have that gets you where you want to be under the statute.
I think it is all of the evidence that was presented at trial, the calling the child her child, adding, I believe it was adding to insurance policy or a bank account, those kind of things that a parent would do. And what others believed. This was a couple. Did others believe that this was that is notorious by its very nature, what others believed. This was a joint shower, those kind of things that they had. They were a family unit, and this child was born into that family unit and lived within that family unit the first year of her life. And that goes to notorious.
Are there other questions? Thank you, counsel. We will take this case under advisement.